So let's start with the delivery of documents to the association. Currently, there's nothing in the code at all about how one would deliver documents to the association. Under the new code section 4035, if documents must be delivered to the association, they can be delivered to the person designated in the annual policy statement, and I'll come back to that in a moment. That designation is going to be who that person is who can receive the notice, or it can be the default, which is the president or secretary. Just so we're clear, this is different than what you do with the Secretary of State saying you're entitled to accept service on behalf of the association. This is a different collateral notice. It has to go out in the year-end documents. It's in one of the two packages, and this goes into the annual policy statement. And this statement is very clear. I, so-and-so, managing agent for such and such, will receive all documentation. The way for the association, the way the statute is written is if you don't do that, it defaults to the president or secretary until the next annual change. My reading of those words is, are you kidding me? For a year, your board members are going to be getting these documents instead of coming to the managing agent. So it's on the checklist. You'll just add it. It is a new thing, but it's a minor thing. If you miss it, it is a big deal. How is information going to come to the association? Well, it's going to come by email, fax, or if the association is consented to email, or personal delivery. And personal delivery is the association will consent to personal delivery, and that can be for your on-site managers to the on-site location, or to the association's managing agent, to the management office, or they can designate officers of the association as well. If the association says we're going to accept personal delivery, it's your obligation to provide the receipt for the document. The homeowner doesn't have to make a demand for that document. So I could just see somebody saying, no, they didn't deliver that, and they say they did, or worse yet, they're going to say, no, I have this, and I delivered it, and I didn't get a receipt. They violated the statute, being small claims court, $500. It's going to be one of those things. So it's easy to do. What documents come to the association? Corporate documents, demands for IDR, demands for ADR, petitions for removal, all the fun stuff that the boards receive information on. I personally think those things really should go to the association's community manager because you're in charge of the business of the association. So the big ticket item on that is designate whether you want to do it and make sure that you designate who the person is. And remember, if the association is going to accept communications via email, there has to be somebody who's going to be committed to reviewing those email and able to take action items on those email. My concern is that we all have spam filters, and depending on how crazy our homeowners are, the spam filter is set really high or it's set really low. And so I'm concerned that if you're going to accept notice via email, which, I'm a big fan of email, at least we do everything that we can via email, that you will have to have systems in place to check your spam filters to make certain that messages that you actually want to receive or retrieve will be coming to you. And so one of those things you'll be working with your IT people to figure out how to do that most effectively. Distribution and delivery of documents and notice. There's no distinction in the statute for individual and general delivery currently. Individual and general, those are the phrases that you're going to be hearing a lot today. Under 1350.7, all documents that are currently required to be disclosed to the association could go out any way that a communication can get from one place to the other. Personal delivery, first-class mail, email, fax, publication in a widely association circulated communication, newsletters, websites, all of those things will constitute delivery of information to those different medias. And if your association is large enough, you're going to have access to do your distributions through broadcast television. We have a couple of our clients that are big enough to take advantage of that, and that's pretty cool. They just put it on the TV and it loops all day through meeting notices and everything else. So what is individual delivery or notice? What exactly does that mean? Well, the new law, which is 4040 of the code, and they're actually, in how the statute was rewritten, the parts of the code and the numbering are very specific to certain topics and subject matters. So you don't have things sort of stuck in other places. Cyrus told me to say to each of you, you can just prepare a little outline of the subject matters and put the code numbers that are in those subject matters together on a list, and it will make it easier for reference. I think you should ask him for the document he prepared, but that's up to you. I think it really will be helpful because you know what things are more difficult for you to understand. And I think that's really the point. If you group them together, it might be easier for you to have the comfort level. Anyway, 4040 says, if documents must be delivered by individual notice, the delivery must be by first-class mail, certified express mail, or overnight delivery, all addressed to the last shown address in the association records. So this is a really big thing for us, and it's a big thing for us because of association lien services. When you do non-judicial foreclosure, you get it all right, or you have to start over again. There's no like it was sort of right, it was close to right, we'll petition the court not to care about the middle initial was missing. And when it comes to where do we find the homeowner, you have the right, and the statute said and says, you get to rely on the address given to you by the homeowner. When you, Susie and Tom, extra special manager, tries to go find out where that homeowner is really living, you create a duty which you don't have by statute. And once you create that duty, it can travel with you. So yes, Susie did move to this place, but then she moved again, and you didn't need to send out a notice. You didn't follow her to the new place. You sent it to the old address, not the one she gave you, but the one you found, and all of the additional notices that were supposed to go to her never went to her. But they weren't returned to you either. They went to this big vat of wasteland of mail. And if that homeowner says you did not utilize the address that I gave you, there could be defective notice. So we all want to do the extra. When it comes to these addresses, it's up to the homeowner. If they don't ever give you an address, for some reason through escrow, maybe there was no escrow, maybe it was a transfer, interfamilial transfer of property, and you don't have the address. You've tried to get a hold of the homeowner, they pay their assessments, but they don't have a check, they send cashiers or they wire the money to the management company, whatever system that you have in place. And if you don't have that address, you actually mail the envelope to the association at the mailing address in which the association said they're going to accept mail. So it's either your management office, or if it's an on-site recreation room that has an on-site manager's office and the mail goes there. Whatever that address is, you mail that notice. Doesn't get opened, obviously, and you just keep it as part of the corporate record because the code says you can do that, and it allows you to meet your compliance obligations. So I like that as well. So this is individual, this what I've just described, it's to one homeowner, it's not to the entire membership. Now you'd think since they just rewrote the Davis-Stirling Act, they could have actually gotten that correct, but there are 4 exceptions to this, and I will talk about them and point them out. But in all fairness, the new Davis-Stirling Act actually points out for you and says, even though this is a general notice item going to all of the members, individual notice is required. Because we're going to find in a second that individual notice is more difficult to meet than general delivery notice. So general delivery is clearly when we're trying to send out documentation to all of the members. 4045 of the code says, if the document can go out general delivery, then delivery must be by any method of individual. So it qualifies if you send out general delivery in a manner that satisfies individual, in a billing statement, newsletter, or other document using one of the methods that we just talked about, or I will be talking about, posting printed documentation in a prominent location accessible, not that it's seen, but could be seen by all members if, and here to me is the second biggest thing in the Davis-Stirling Act, if the location is designated for general notices in the annual policy statement. So remember, there's two statements, the financial ones, the annual policy statement, and in the annual policy statement, you're going to say, on a stick, 2 feet west of the entrance of the clubhouse, or right near the pool, or at the corner of such and such and such and such, we will post general notices. And if you say that in this annual policy statement, you can do that. Well, there are a lot of general notices that can go out that way, not the least of which, my personal favorite, which is sending out rule changes to the members for their comment can go out by general delivery, which means you can stick it on a pole, you can tell the homeowners, this is what it is, 3 of them will see it, 1 of them will read it, and I'm assuming it's going to make our lives a lot better. So you do not want to miss the opportunity to take advantage of this during the course of the year. I think it's just going to be a really good tool for you and our boards. Of course, any member can actually ask for individual delivery, even though the statute says it can be general delivery. And I don't know how easy that's going to be to track, but if they ask, you have to send it to them individual at the association's cost and expense. Electronic delivery. There's no explicit provisions currently in the Davis-Stirling Act for whether electronic delivery satisfies a writing, when it says you have to do this in writing and you have to send out a written communication. And the new Davis-Stirling Act, it says that electronic communications do constitute a writing as defined under the statute. So for those of you that haven't had to deal with that issue before, yes, Mark?
Go back a slide there, Sandra. There you go. There you go.
Thank you. If you haven't had to, it's not holding.
Uh-oh.
Okay, let me know if it moves again. Thank you. If you have not dealt with that issue before, it spirals out of control with the homeowner saying that they got notice, or the homeowner saying we did not get notice. We never said we could communicate with the board of directors via email. They still have to consent to electronic transmissions. I'm thinking this is a great year to ask them again for their email addresses when you send out your notices. Maybe you send them an email if you have their email addresses and just say, please hit reply, and that will constitute your approval for us to communicate with you via email. So the new section 4055 says that if the member consents to electronic delivery, you can do it for all of your general communications, and if the homeowner says that they will accept individual, you can do it for individual as well. But you have to be able to reproduce the content of that electronic communication in a printable form. And we've seen that in other statutes, that you have to be able to maintain a record in a printable form. So what this means is that texts are not allowed, although those that are more text savvy than others know that you can easily convert that text and put it into a document, but because of by its construction and its nature, it's not easily printable. It's not going to be, at least for this round, going to be allowed. You want to be able to just be able to keep it, to retain it, and to be able to use it as proof if the association needs to actually have proof. So, general, individual. For general, you can go any way individual, plus, my favorite, the posting, and electronic if the member says, yes, you can communicate with me electronically. Yes, Sue?
How about a website? Is that allowable as electronic?
Well, I think the answer is yes, but I have to qualify it by say I think, because it doesn't, we looked at the legislative history on it, we did not see anything that specifically said you can do it. The reason that we think that it will constitute general notice is, assuming the homeowner says that they will accept information electronically, is because you can use broadcast media, which is like the televisions, and that is not as easily identifiable as a website is at a moment in time. And so we're just assuming that if the more difficult is allowed, then the less difficult should be. But we do believe that you do have to still get that consent for electronic communication. Unfortunately, the legislature is just not catching up as quickly as we'd like them to do, to be with technology, but hopefully as it moves along,